So good morning, everyone, on this rainy Thursday morning. Welcome to our latest employment law webinar, and I'm Meredith Hurst, one of the partners in the employment department here at Thomas Mansfield, and I'm joined today by my colleagues Jenna, Ide and Alex Kiernan, who are also partners in the department.
Morning, everybody.
So for those of you who don't know Thomas Mansfield, we specialise in 4 areas: employment, obviously, family, litigation and private client. And here in the employment team, we work with HR managers as well as business owners. So today we're going to be talking to you about disability discrimination and managing evolving types of disabilities. The modern workplace is rapidly changing, and disability discrimination as well is ever evolving and becoming more and more complex, which can give rise to a number of issues at each stage of the employment relationship. And we're going to be looking today at managing disability discrimination in the workplace. And I'm sure you'll agree that the situation has been changed by the pandemic, and we're looking at how people are now working in different ways, working from home, and so face-to-face contact with employers is reduced. And also the disabilities that people are experiencing have altered in the last few years as well. So, for example, long COVID is something that we didn't hear about before. There's also a greater understanding and awareness of conditions such as, well, it's not really a condition necessarily, but menopause and neurodiversity, dyslexia, ADHD and the like, which means that it's important for us all to understand how to deal with those conditions. Not least because, as I'm sure you'll already be aware, compensation is not capped in the context of disability discrimination claims. We'll be covering a number of conditions today, and we'll also be looking at some helpful case examples, and I'll be putting up a handout for you in a few moments. We'll be taking you through the key concepts of disability and what those mean for managing these new developments. And we'll also look at so-called hidden disabilities. So without further ado, I will make the handout available to you. And let me see if I can do that. So I'm now going to share the handout there, available in files for you. Please do feel free to ask questions along the way. And I'm looking in the chat. Yes, please do pop any questions you have. And we'll kick off with Jenna. So Jenna, could you please explain how can employers tell which conditions are classed as a disability?
Well, unfortunately, I can only give you a really small list of conditions that are definitely classed as disabilities. So these are what we call deemed or automatic disabilities. And as examples, we've got cancer, HIV, multiple sclerosis, severe disfigurements, and sight impairment. So any employees with such conditions would be classed as disabled automatically. Some conditions are excluded from being disabilities, such as an addiction to alcohol, but we won't be focusing on those today. So for all other conditions that don't come under those categories, the decision about whether the employee is disabled or not is ultimately one for the tribunal to decide, which of course makes it really tricky for employers because you can't just consult a tribunal to ask the question. And what that means is that in certain circumstances, it's often safer for employers to err on the side of caution and to treat potentially disabled employees in a sensitive manner, just in case a claim is brought and a tribunal later confirms that the employee was in fact disabled at the relevant time. So let's have a quick look at the framework, which includes the 4 disability tests. So these are the tests that the tribunal will be looking at to see whether an employee is classed as disabled or not. The first is that the employee must have a mental or physical impairment. Usually that's not much of an issue. Secondly, that impairment must have a substantial adverse effect on their normal day-to-day activities, and activities does include work activities. And where I've just mentioned a substantial adverse effect, that only means more than minor or trivial. So it's a relatively low bar. And thirdly, the impairment must have long-term effect, so it must have already lasted for at least 12 months, or it's likely to last for 12 months. So that's the test for whether an employee is classed as disabled or not, that the tribunal will look at. And it's worth noting while we're on this topic that some employees will have disabilities that they're not even aware of themselves. That's something that's really common with neurodiverse conditions. Loads of people will be unaware that they're dyslexic, for example, and it's not until issues arise in the workplace that it will be identified. There's the case of Fothering and Perth and Kinross Council. The case name is on the handout. That discusses the situation of a teacher who initially did not realise that he was autistic, but he did later receive such a diagnosis. It's also common for people with the menopause or the perimenopause to have symptoms but not realise what it is. Brain fog might just be put down to ageing, for example. In the context of the menopause, employers should be aware that it has been held to be a disability in some tribunal cases. So the menopause should really be treated with great caution, especially because the menopause touches on potentially 3 protected characteristics. So not just disability, but also sex and age. So that is a particularly risky area. We're also going to be touching on some cases involving COVID later on, as Meredith mentioned, which will show that long COVID can be a disability as well, but it can be hard for employers to judge. Ideally, of course, taking all of this into account, line managers need to have a good working knowledge, at least, an understanding of these conditions such as dyslexia, menopause, long COVID, so that they will, be able to appreciate what these conditions mean in practice.
Yeah, thanks for that overview. That's helpful. So, Alex, moving over to you, can you give us some examples of how the tribunal has applied these disability tests in practice?
Yeah, of course. So one relatively recent example I could give you is the case of Parnaby versus Leicester City Council. This is a 2019 case. Essentially, Mr. Parnaby, he's a head caretaker at the council. He's off sick in relation to work-related stress and depressive disorder. He has about a month off in 2016, and then he has this longer spell off in 2017 from January to July, so about 6-7 months. Following that spell of sickness absence, he's dismissed. That's for capability reasons at the end of July. Ultimately, he brings a claim for disability discrimination relating to his mental health, and clearly a dispute arises. But the dispute was focused really upon whether or not his stress and this depressive disorder constituted a disability within the test that Jen has just gone through. It's quite important to highlight that actually all of these conditions were in the medical notes centered around his workplace, work-related stress. And it was a key fact in this case that his health improved, and that wasn't in dispute after he was actually dismissed. So in first instance, in the employment tribunal, they took the decision that this wasn't a disability. And ultimately they found that it did have substantial adverse effect on this individual's day-to-day activities. So that was tick there on that score. But the area where it fell down was they decided that actually it wasn't long-term. So this is looking at, was this condition likely to last for more than 12 months or reoccur? And the judge in that original case observed that essentially the health improved shortly after dismissal. So it evidently wasn't likely to last for more than 12 months. Mr. Parnaby appealed that decision, and on appeal, it was overturned. Why was that? Well, it was overturned on the basis that the Employment Appeal Tribunal said, look, it's not right that you should use the benefit of hindsight. What you need to do is effectively place yourself in the shoes of the employer at the time they're taking those decisions. And it's in those circumstances that you ask the question, is this likely to last for more than 12 months? And that was an error that the tribunal and the employer made in that case. And ultimately, it went back to the ET, and it was decided that that this did constitute a disability. So I think that's just quite an interesting example of how complex it can be on just one strand of that test.
So you're looking at the position at the time rather than with the benefit of hindsight. And I can imagine that is it's a difficult decision to grapple with. So Jenna, could you give us another case example of how a tribunal has applied these tests? And I think if viewers listen to the facts, we're going to have a poll afterwards. So house points for those of you who are listening. Over to you, Jenna.
So I'm going to talk about the case of Mrs. Roberts and Enfield EM international diagnoses from her GP. And in terms of how she was affected, she had sleep difficulties and was put onto sleep medication to deal with that. She was also put onto medication to help with her low mood. She did have dark thoughts, but no plan or intent to harm herself. And she did also have some difficulty caring for her daughter at times as well. She also had a fear of returning to work, and then once she did return, she experienced difficulties at work as well. And she did end up being signed off sick at various points due to her conditions. So I believe Meredith has just added the poll for everyone to look at. So if I just read the question quickly for everyone. Do you think Mrs. Roberts' anxiety, depression, and postnatal depression were held to be disabilities? So we've got yes, no, only one of them, or not sure. So I'll just give you a minute to place your bets on that, and then I'll hand over to Meredith to give the answer.
So we've got 100% of people at the moment believe that we've got a bit of movement now. Still, the majority, I think, are saying yes. Only one of them not sure. And okay. So yes, being the resounding majority still, and I think we'll end the poll there. And hopefully we can see the results there. 59% yes, 12% no, 18% only one, and 9% not sure. So the answer was, in this case, the tribunal found that Mrs. Roberts' anxiety, depression and postnatal depression were not disabilities, as they didn't have a substantial and adverse effect on her normal day-to-day activities. The tribunal went on further to explain that even if there had been a substantial adverse effect, the mental impairments in particular were not likely to last at least 12 months at the relevant time. It goes back to this point that Alex was mentioning. The tribunal noted that the claimant had given evidence of the adverse effect on day-to-day activities only in very general terms, and the tribunal appeared to rely, but quite heavily, on the GP notes rather than the claimant's assertions about how she was affected. And I think that's a lesson that we've come up against in real-time cases where a disability impact statement can be very detailed and quite drastic in nature, when in fact the medical records do not support that. So we'll end the poll there, and I'll reshare the case notes. So we're now moving on to look at knowledge, which is an important feature in a disability context. So Jenna, can employers escape liability by claiming not to have knowledge of an employee's disability? Perhaps you can talk us through that thorny area.
Yeah, sure. So it basically depends on the type of claim we're looking at. So we're going to come on to the various claims shortly. Alex will talk about those. And most of those will require the employer to have either actual knowledge of the employee's disability or, as a minimum, constructive knowledge. But what does constructive knowledge mean? Well, it means that the employer ought to have known. So, for example, that there were signs there, and perhaps the employer turned a blind eye to them. So in the case of McMahon and Rothwell and Evans LLP, which is a law firm, an employee downplayed her menopausal symptoms, and that was a large factor in the tribunal finding that the employer didn't actually have any actual knowledge or constructive knowledge of the menopause in this case. And this was even though the sick notes actually referred to the menopausal symptoms. But here the tribunal said that the sick notes were just sent to the payroll department for the mechanical process of paying sick pay, and they weren't actually viewed by anyone within the law firm with any form of responsibility. So there was no knowledge at all in that case of the disability. So in relation to reasonable adjustments that we'll come on to shortly, it's worth noting that an employer must also have knowledge of the substantial disadvantage or the barrier at which the employees put before it can be under the duty to make reasonable adjustments. So with reasonable adjustments, you've got to have the knowledge either actual or constructive of the disability and also of the substantial disadvantage as well. However, the potentially very scary thing for employers is that there is one claim, again, we'll come on to this, that they can be liable for, even if they have no knowledge of the disability whatsoever. And the claim I'm referring to here is a claim for indirect disability discrimination. So that's why it's really important to review policies and procedures to ensure that there's no disparate impact on disabled employees and to ensure that any justification arguments by way of a defence are well documented in case they are needed as evidence later on. And Alex will speak shortly about the possible defence I've just mentioned using epilepsy as an example.
Thanks, Jenna. So, Alex, can you talk to us about what types of discrimination claim can occur in this context?
Yeah, of course. So I think often HR and employment solicitors talk about the 4 types of discrimination, and that can be misleading when we're dealing with disability discrimination, as we are here. You know, there's actually 6 different types. There's 2 sort of add-ons, if you like, when we're dealing with disability. I'm going to go through the different types fairly briefly, just as a key reminder for everyone. So we've got direct discrimination. You know, this is probably the most legally straightforward. This is essentially where employer, let's say, treats the disabled person less favourably because of their disability. So often this is an intentional act, can be unconscious, but in its most obvious form, this is, you know, I'm dismissing you because I don't want to work with someone who has a mental health condition. The second type that we've got is this indirect discrimination that Jenna mentioned. And you know, often this is a sort of policy that's put in place or a requirement placed on employees. It's where it applies to everyone in the business, but it essentially puts that disabled person at a particular disadvantage that's comparative to other individuals who are not disabled. And then off the back of this, we do have this sort of objective justification test where you can evade liability if you can demonstrate that this policy was a proportionate means of achieving a legitimate aim. So what does that mean? Well, as a really brief example, I think a good example is if you put out a job advert, let's say, and say that all applicants need to have a driving license. That's not on the face of it discriminatory. However, it could be that someone has epilepsy who's going to be applying for that job, and actually because of that disability, they are unable to they're put off applying effectively. That still may be objectively justifiable if, of course, the job is doing something like a taxi driver or a bus driver, something where it's inherently the case that they're going to have a driving license to drive in the job. If, however, it is a scenario where it's a teacher and let's say they're driving once a week between 2 different school sites, it's going to be less obvious that is objectively justifiable. I think it probably wouldn't be. So that's indirect discrimination. The next, sort of category 3 is harassment. Essentially, this is unwanted conduct that's related to someone's disability. And it has the purpose or effect of violating their dignity, or there's various categories, creating an intimidating, hostile, degrading environment for them. We have a subjective element. How did that person feel about it in the test? And then also an objective element. Was it reasonable for that person to have felt that way? Good example I always think here is a case of Davis and Remploy. This is where a person who was wheelchair bound was nicknamed Ironside, obviously named after the TV detective, and he was called, this was banded about in the workplace. He complained about it, said it offended his dignity, and ultimately he was successful in that claim. And then the fourth of the main claims is victimisation. This is where a protected act occurs, and most commonly this is where someone complains about many of these other aspects. So someone complains about being discriminated against, and effectively they suffer a detriment, they're punished because they've made that complaint. Classic example I always think of is I once had a case where we were in tribunal, brought a claim, and the old employer whom we brought the claim against essentially phoned up new employer during the middle of these proceedings and slagged off effectively the claimant and told them that they shouldn't employ her. You know, that's a classic example of that type of action. Then that puts us on to the two probably more tricky areas when we're dealing with disability discrimination, common battlegrounds. In lots of the cases, Jenna and I are going to come to talk to you about. So we've got a failure to make reasonable adjustments. I think many people will be aware of this one. It breaks down to three main areas. It's where there is what's known as a PCP. So again, like a policy or a requirement in the workplace that places a disabled employee at significant disadvantage compared to those who aren't disabled. A physical feature, again, which places them at significant disadvantage. And also there's if they could be provided with an auxiliary aid that would reduce that significant disadvantage, then that's another form of reasonable adjustment that could be made. An employer is only required to take such steps as is reasonable to avoid those disadvantages being suffered. And that's an important point. You know, it's often an argument we get into as solicitors. Well, was it reasonable? Was it not reasonable? Essentially, the employer is not required to take sort of disproportionate undertakings in order to accommodate. So we do have some guidance on this. I would encourage you to have a look at it's the Equality and Human Rights Commission's statutory code of practice, which is really helpful. Some of the factors which are looked at in determining what is and what isn't reasonable include the extent to which that adjustment, if applied, would alleviate that disadvantage. So if you're going to spend lots of money on something and it's only going to help in a very minor way, then that indicates that it probably wouldn't be a reasonable adjustment. The extent to which it's practical, and the cost is a big one. You know, looking at the financial impact on the business, and when looking at that, it's also looking at the size and administrative resources of that business. So those are some of the sort of bases on which the test is applied, and hopefully that gives you a fairly good explanation.
Yeah, thanks, Alex. That is really helpful. And another thing to bear in mind is claimants have argued that that their right to be paid sick pay is an adjustment, whereas in fact it isn't. The policy behind adjustments is to encourage reintegration back into the workplace. So don't be misled on that one. To help illustrate the duty on employers to make reasonable adjustments, Jen is now going to describe a case, and then we're going to have a poll again to see whether you think the proposed reasonable adjustments were upheld by the tribunal or not. So over to you, Jenna.
Thanks, Meredith. Right, so I'm going to speak about the case of Mr. David Muzi-Mabazo and Secretary of State for Justice. So David was a dyslexic probation services officer, and his manager gave him 2 OASIS reports to complete with a deadline that was 3 weeks later. And each report would usually take at least a day to complete. So in theory, he's required to complete 2 reports, so it would normally take 2 days. But taking into account David's annual leave that he had during those 3 weeks, he actually only had 6 or 7 working days to complete the reports. And of course, you have to bear in mind he did have some other work to carry out during those days as well. David managed to submit the draft reports to his manager just before his holiday. But on his first day back from holiday, his manager expected him to complete both reports by 4:30 p.m. that day. So the question here is, would it have been reasonable? Would it have been a reasonable adjustment for the manager not to have required David to finish off the 2 reports that day? So I believe the poll question has been loaded. So yeah, do you think it would have been a reasonable adjustment for the manager not to have required David to have completed the 2 reports that day by 4:30? So we've got the first answer, yes, it would have been a reasonable adjustment to have not required him to complete the reports that day. no, it wouldn't have been a reasonable adjustment. That 4:30 was absolutely fine, and the final one, not sure. So I'll hand over to Meredith for the answers.
Interesting, yeah. So we've got, again, a significant majority of people saying that it would have been a reasonable adjustment at the moment. No one sitting on the fence today on this one. So racing into the lead, yes, it would have been a reasonable adjustment. 4% not sure. So I think we've settled on roughly 60% of the viewers do think it would have been a reasonable adjustment. That is the correct answer. It would have been a reasonable adjustment. Not to have required David to finish off the 2 reports that day. This case is a salutary reminder, I think, to consider workload issues for neurodiverse employees in particular. It's also worth adding that although David's complaint to the tribunal was 4 months out of time, he was also allowed to proceed on the basis that it was just inequitable to extend time, which was partly because he was pursuing an internal grievance, and also likely because of his disability as well. So we have one further type of disability claim. Can you cover this for us, Alex, please?
Of course. Yes, so that final one, and another really common battleground in disability discrimination claims, is the reason arising from complaint. This is often quite misunderstood, and essentially this is where circumstances that arise from someone's disability result in them being treated unfavourably. So you've got something arising, and that something causes that unfavourable treatment. And we also still have this objective test, which is whether it's a proportionate means of achieving a legitimate aim. So let me give you a little example to illustrate the point. Let's say you have someone who's suffering from dyslexia. Maybe they're on their probationary period, and they produce lots of work that has lots of typos in, grammatical errors, etc. Let's say they are dismissed because it's a solicitor's firm, and they say, look, it's not coming of our firm to have these types of letters going out. They're dismissed. The reason for their dismissal is the poor writing skills, not the disability, but the poor writing skills flow from the disability. And then the next question would be, is that a proportionate means of achieving legitimate aim in that case? I suspect it probably wouldn't be. Obviously, it depends on the fact, but I think an employer would have to think really carefully about what measures they could put in place to assist that employee to address the issue.
Thanks, Alex. Jenny, are you able to give us another case example of this discrimination arising from disability?
Yeah, sure. So I'm going to talk about the case of Mr. Wells and the governing body of Great Yarmouth High School, which again is listed on the handout. And it involved an autistic maths teacher who was absent for 209 working days, so not far off a whole year, across just over a 2-year period due to anxiety and depression. And while he was off sick, the school, of course, had to hire the supply teachers. The school ended up dismissing him on capability grounds, as I'm sure you wouldn't be surprised to hear, due to his lengthy sickness absence. But the question here is, did the claimant actually succeed in his claim for discrimination arising from a disability based on the dismissal? Was that a form of discrimination? And in this case, it actually was. The dismissal was held to be unfavourable treatment. It's common for that to be an unfavourable type of treatment, but it was due to the sickness absences, and the sickness absence obviously it arose in consequence of his disabilities. And the school did try to rely on the defence that Alex has just described, by arguing that the dismissal was a proportionate means of achieving a legitimate aim. So the school, of course, had a need for teachers to turn up to work, and they were incurring the cost of the supply teachers to cover his absences. But the tribunal held that his dismissal might have been avoided if the school had taken steps to find out about his condition and the adjustments that could have been made. So the defence failed, and he won his claim for discrimination arising from a disability. And it's worth mentioning in the context of this case that the tribunal was satisfied from the medical evidence that given that the teacher had autism, he was more likely to suffer with severe and long-term bouts of anxiety and depression. So the anxiety and depression were inextricably linked to his autism. The tribunal also held that once the school had actual knowledge of the claimant's autism, they ought reasonably to have known that his anxiety and depression flowed from that condition. So it's a really risky area there, one to be aware of. And a final few points to note about what happened in this case. Because the dismissal was held to be discriminatory, his claim for unfair dismissal also succeeded. And his claim for indirect discrimination also succeeded in that the absence procedure, when it was obviously applied to him with its trigger points that he triggered, did put those with a disability at a particular disadvantage, as the test requires. And that was the case even though the policy stated that the disability-related absence may need to be discounted. And the final point to note about this case is that the tribunal
Jenna, if a dismissal is a result of two causes, one of which is not linked in any way to a disability, would the outcome be different, do you think?
Well, so I mean, I'll give the usual caveat of how each case will turn on its own facts, of course, but the general answer is that where there are multiple causes of the dismissal and some of the causes don't actually arise from the disability, then as long as there is actually one cause that does arise from the disability, that is sufficient for the purposes of this type of claim. And just as a reminder, we're looking at the claim of discrimination arising from a disability. And so at this point, I think it's probably best illustrated by way of a case example. So we're going to look at the case of Mr. Lewis Davis and Switch International Trailers UK Limited. So the claimant, Lewis, had PTSD. He worked as an HGV driver for a road haulage company, and his PTSD was found to be a disability, so it wasn't an issue here. And he complained about the effect that route changes were having on his PTSD. So after a bit of an argument with his manager by text, he ended up being put through a redundancy process by himself in a pool of one, and then dismissed 5 weeks later, allegedly on the grounds of redundancy. And the Employment Tribunal found that he had been dismissed because of two factors. So the first one was his inflexibility about start times, but the tribunal found that issue arose from domestic convenience. It wasn't in any way related to his PTSD. So there's the one factor that isn't related to the PTSD, but the other factor was his inflexibility about route changes, and that did arise from his PTSD, and that was backed up by medical evidence. So we've got the two factors here that were the cause of the dismissal, one relating to the disability, one that wasn't. And the question is, did he succeed in his claim for discrimination arising from a disability? So he did succeed. The dismissal was held to be unfavourable treatment due to his inflexibility about the route changes, which arose in consequence of his disability. And it didn't matter that there was another non-discriminatory reason. What mattered that, one of the reasons for his dismissal did arise from his disability. So it's a real pitfall for employers to be careful of. And as Alex has mentioned, there is a potential defence to this type of claim, but in this case, again, the defence failed, as the tribunal held that although there may have been a real need to reduce driver numbers, it was wholly inappropriate to achieve that through a targeted dismissal, and nor was it necessary. The tribunal stated that a neutral and non-discriminatory process would have, of course, been the appropriate way to have achieved any legitimate aim.
Okay, thanks, Jenna. I think we're doing pretty well for time today, and we have just got a question come in, which I'll throw out to the panel, and I will also help if necessary. How is reasonable to know decided? That I guess the question is how does an employer establish knowledge? How does an employer not stray into diagnosing people or making assumptions? For example, anxiety, depression being linked to a neurodiverse condition. I think that's a very good question. I did actually have a case where an employer made a diagnosis, potentially incorrectly, of an individual who then brought a claim for perceived discrimination, that he'd been perceived as disabled when in fact he wasn't. Do you have any thoughts on that, Jenna?
Yeah, I mean, I would say it is obviously very dangerous to start working on the basis of assumptions. And I think that's one of the reasons why training is so important, but also obtaining medical evidence. So, whenever a potential issue arises in the workplace, maybe someone is constantly turning up late, obviously speak to the employee. If there is the potential for some kind of mental health issue, or you suspect a neurodiverse condition, you have to deal with it really sensitively and avoid overtly, making those assumptions.
I think that's good advice. A couple of other questions, and I think we'll move back to the presenters. But we've had a question saying that an employer has not deducted disability-related absence from an absence record for purposes of sick pay. Is that advised? I mean, I would say you do need to consider deducting disability-related absence if it then has a knock-on effect on remuneration, because that tendency would lead to a discrimination arising claim and also potentially a reasonable adjustment claim. But of course, it will depend on the nature of the condition and the absences. I don't know if you guys have any further thoughts on that.
Yeah, I mean, it actually leads quite nicely onto a case that I was going to pick up on. I would say that it's certainly an area that is very, managing sickness absence and thinking about disapplying disability-related absence from those procedures is it's an area where there's a sort of litany of cases around it. And I think,
well, Alex, why don't you talk us through that, because I think you were going to anyway, and then maybe we can turn to the other question we've got afterwards, if that's okay.
Yeah, fine.
Great. Okay.
I think some of the key points I would make is, look, you have to be really careful to obtain medical advice in this situation. I think exactly what Jenna said, one of the most obvious routes is just talking to the employee as well and finding out information from them, which can sort of steer you in a particular direction. And it's important to take proper account of the impact of that disability when looking at those sickness absence procedures. A case that I sort of picked out here that's fairly recent, I think illustrates the point fairly well, is this case of Mackenzie versus University Hospitals of Leicester NHS Trust. Essentially, we're dealing here with this is involved a nurse. She went through long-term sickness absence procedures. Cutting a long story short, essentially, she was on and off of sickness absence procedures for I think a period spanning about 7 years. So what would happen is she'd go through all these procedures. She'd get, I think in one case, she did about 4 years in, get to a final written warning. Then her health improved, and then they restarted the procedures again. This on-off sickness absence was for various reasons, which made it quite complicated. She was diagnosed with depression in 2018, but was also suffering with stress, anxiety. Her absence continued to be quite poor, but continued to be really mixed reasons. She had a broken ankle at one point, she suffered with migraines, and then there was the depression as well. They had an occupational health report, so they sought that medical information. That was, I think, in the beginning of about 2020. And that made a number of recommendations. One was that she have a phased return to work. And it also said that if that didn't work out, that the employer should consider redeployment to a lower bound role, basically, a more junior position. This individual ultimately ends up on a final written warning near the start of 2020. Whilst on this final written warning, she has 2 further bouts of sickness. The first is COVID related. Some related really to any of the disabilities. The second is in relation to migraines. Sitting on this final written warning, the NHS basically go through through their process, and they dismiss her. She has, at that moment, I think it's 8 times their sort of target in terms of 8 times worse on the sickness absence level. And she's dismissed for capability reasons. Ultimately, it was held that that dismissal was discriminatory, and the actual claims were discrimination arising from, which we talked about, and failure to make reasonable adjustments, as well as I think it was unfair dismissal. But I think it's interesting to highlight that, I suppose, firstly, it was deemed that these conditions were a disability. You know, they were long-term, they had substantial adverse impact on normal day-to-day activities. But secondly, the employer was actually criticised quite a bit. It was said that they got medical evidence, but they'd failed to properly consider it. So that's a really important point that we've spoken about. They'd also failed to consider one of the key recommendations of the occupational health report that I mentioned, which was this redeployment. They just failed to look at it really and consider it at the point where they were going to dismiss. And thirdly, probably the biggest one, which is related to that question that we've had, is they failed to take account of the disability-related absence and subtract it from the sickness absence levels when implementing their policy. So, yeah, the case law tends to indicate, essentially, in answer to that question, that as Meredith says, it does really depend on the facts, and it's always annoying when solicitors say that, but you think very seriously, if there is a disability there, about deducting that when taking decisions.
And we'll have one further question, and I think we'll get back to the. I think we're doing okay for time, but we'll just deal with this one further question. So, is it a good or bad idea to ask employees to complete a health assessment on joining? Would that potentially highlight any disabilities? I mean, there is a specific statutory provision about not asking certain medical questions, and obviously you've got the sensitivity around whether someone with, say, a mental impairment actually discloses that condition, because they may fear that it will be to their detriment. But I don't know if you have any thoughts on that, and then we'll move forward with the presentation.
Yeah, I mean, I would say from a purely legal perspective, an employer might think it's a bad idea to ask questions about a disability once an employee has started their employment, because the employee may then respond and say, I've got depression or, some other potential disability. And then you're left thinking, oh, we've got knowledge now. So now what do we need to do? And you might think it's a bit of a headache. So you might steer away from finding out, but actually, in the broad scheme of things, it's up to the employer to decide what approach they want to take with disabilities. If they want to be disability inclusive, it's better to find out right at the start of employment, so that adjustments can be made, the right support can be put in place, and it will then reduce the turnover rate of staff, hopefully, as well, and the associated costs.
Okay, thanks. We've talked a lot about cases involving hidden disabilities, and we're going to move on to look at long COVID now. And that can be something that persists even once they're testing negative. It's a relatively new condition. The question then is, are employers at risk of discrimination claims if they don't properly handle employees suffering from the condition? And there are 2 rather intriguing cases which show opposite sides of the same coin, which Alex is going to talk to us about now.
Yeah, so the first of those cases is a case of Burke versus Turning Point Scotland, rather. And this involved another individual who was a caretaker, Mr. Burke. He got COVID in November 2020. He was then really severely affected by it. He suffered with severe headaches, fatigue. He gave evidence indicating that actually just getting dressed, getting in the shower, resulted in him feeling so exhausted that he had to lay down. Ultimately, examining this evidence, when looking at how did it affect normal day-to-day activities, the evidence was very much that he struggled doing just normal things like cooking, ironing, going to the shops. And in this case, he was off sick a lot of the time. His sick pay was ended and then ultimately he was dismissed on the grounds of ill health. Obviously, he brought a claim, and ultimately it was decided that this did constitute disability. So this is a case where the long COVID did constitute disability. It was found that it did have some adverse effect on his normal day-to-day activities. It was substantial. It was long-term, those tests that Jen has gone through at the outset. And it was found that it could well last for much longer.
Thanks, Alex. And Jen is going to talk to us about another case that deals with long COVID.
Yeah, sure. So I'm going to talk about the case of Jillian Quinn and Sense Scotland. It's from August this year, so a pretty fresh case. So Jillian had underlying health conditions. She tested positive for COVID around the 11th of July last year. The date's quite important in this one. She experienced the usual COVID symptoms of fatigue, shortness of breath, pain, discomfort, brain fog, etc. And those effects did affect her in everyday life and disrupted her sleep. So on the 26th of July, which was 15 days later, Jillian contacted her GP to arrange an appointment. But the very next day, which was 16 days after testing positive, she was dismissed. And after her dismissal, during the August, she was deemed to be unfit to work by her GP due to ongoing COVID symptoms. And then in the September, she was diagnosed with long COVID. So Jillian ended up bringing various disability discrimination claims, and a tribunal had to decide whether she was disabled at the time of her dismissal. The tribunal found she wasn't disabled under the Equality Act, mainly although COVID impacted upon her normal day-to-day activities, the substantial adverse effect that we described, the way she was affected, was not long-term. So it wasn't likely to last 12 months at that time. And it's worth mentioning that the tribunal noted that the substantial majority of people who contract COVID do not go on to develop long COVID and do not suffer from it for more than a year. So it couldn't be said that risk could well happen, and therefore it was not likely to last 12 months. So it failed that long-term element part of the disability tests. So in this case, although the COVID did turn into long COVID, she wasn't disabled at the time of her dismissal.
Thank you. So moving on to our practical tips, which we've all been waiting for. There are two key areas we're going to focus on now. One is proactive preparation to avoid issues arising in the first place, and then the second is proactive management when issues do arise. So Alex, please could you give us tips on proactive preparation?
Sure. So the first one, I've got 4 practical tips, really, 4 main areas. The first is recruitment. So obviously someone can bring a discrimination claim even before they've started employment. So start with looking at your recruitment processes. Look at job adverts and how you assess people in the recruitment process. Think about, is this accessible to people with an array of potential conditions, potentially neurodiverse conditions? Look at things like font size. Look at how you can adapt if someone asks you to do so. And there's lots of case law that underlies that point. The second, and I would say this is quite a big point, is look at training. Training is such a big deal in this area. And once that's useful generally, we have something known as the statutory defence. And essentially, the statutory defence is Section 109 of the Equality Act. And it essentially says that even if someone is found to have been discriminated against at tribunal, an employer can avoid liability completely if it can demonstrate that it took reasonable steps to prevent the employee committing this particular discriminatory act. So reasonable steps can be having regular equality and diversity training. I have a lot of small employers who will be quite cynical about this. And what I would say is, even if your aim is, if you're not convinced by the sort of shaping minds and changing culture approach of this training, then what I would say is, look, this type of training it's not particularly expensive. It's not that time consuming. And if you do it correctly, you can potentially face zero liability if someone, if you have a rogue employee that does go off and do something. So, I would really encourage people to think about that cost benefit of that. Two quick points on that is, obviously you need to do this training before the act of discrimination takes place. And secondly, mention a case, it's a recent one, Alay and Gehin, I'm probably not pronouncing that right, but essentially the point in this case was it was a racial harassment claim, and the employer had done some diversity training and argued this statutory defence as a way of getting out of the claim. And it was found in that case that actually this training that had taken place, but it had taken place 2 years, I think 2 years, 8 months prior to the event of discrimination. And the court in that case essentially said that this training was stale. You can't just do it several years ago and expect that it's still going to be a defence for you. You need to do it regularly. So that's, I think quite an important point. Do consider training in respect of specific disabilities. Lots of companies now will have or looking at mental health first aiders, and they can be really useful. Training middle managers is really useful as well. To get them to understand those cues and think about what impacts there could be going on behind the scenes. Consider neurodiversity, and if you've got mental health first aiders, that they should have additional training in that regard. I also do think that it's worth thinking about, do you have individuals who are sort of effective like neurodiversity champions in the workplace, who have more awareness of it? And I actually think we'll see more of that in the future. My point 4 is get your paperwork right. It's perhaps a bit of a boring one, but it's a really important one. Have a proper equality diversity policy. Do think about whether these newer conditions are reflected within that policy. Does it address things like neurodiversity, things like long COVID, obesity, even menopause, to ensure that you're not setting yourself up for a later dispute. And that's my key 4.
Well, thanks, Alex. I've learned something there, so that's really great. Jenna, please, could you give us your tips on proactive management?
Yeah, so in terms of proactive management, I would say the first tip is that if there's any mention of a health condition or a neurodiverse condition at any stage of the employment relationship, it's a good idea to get early legal advice. As you can see from what we've discussed in this webinar, it's a really complex area of law. My next tip relates to induction forms. Keep an eye out for any mentions of any conditions or even medication on induction forms. Don't just file them away, make sure you read them, take action. And it's really important to obtain early OH advice, occupational health advice, and carefully consider the advice where there are potential disabilities. Don't just blindly follow the OH report if it says that an employee is not disabled. Remember, it's ultimately up to the tribunal to decide whether the employee is classed as disabled or not. And as we've seen, conditions such as long COVID and the menopause can constitute disabilities, even when you think they might not. So just have an open mind. And in relation to neurodiversity, I spotted that earlier this month, AXA Health introduced what they call a group neurodiversity and assessment and support service. It's a bit of a mouthful, but basically it can be bolted on to the existing corporate private healthcare schemes, and it will provide members and their eligible family members with prompt diagnostic assessments. And onward assistance. So, if an employee thinks they might have dyslexia, they can be sent off for, diagnostic assessments. So it's something for businesses to consider adding on to their existing private healthcare schemes. And we've talked about this one already, to be honest. The next one is obviously don't make assumptions about disabilities. So one thing I find in practice quite a lot is that a dyslexic line manager will assume that another dyslexic employee is just like them. So if they don't need adjustments, their other colleague won't either. But obviously every dyslexic person is different and can be affected in different ways. Don't forget about the Access to Work scheme. So companies can obtain funding for adjustments, and it's best to get that in straight away, the applications for the scheme, within the first 6 weeks of an employee's employment, because then the costs are likely to be 100% funded by Access to Work, whereas after the 6 weeks of the first employment, after the 6 weeks of their employment, the company may have to pay a proportion towards the costs, and it partly depends on how many employees the company has. In relation to the Access to Work scheme, there's the surprising statistic that although around 10% of the UK workforce is dyslexic, only 4,500 dyslexic people are benefiting. So 3.2 million being the 10% compared with the 4.5, it's a really small number. Once the reasonable adjustments duty has been triggered, it falls on the employer, not on anyone else. The employee isn't required to make the suggestions. Obviously, I'm conscious of time, but just some final key tips from me. Just make sure everything is documented, engage with the employee about adjustments, and return to work interviews as well. Make sure that they're followed up with, and check also that the managers understand how to fill the forms out properly as well. And the last point from me is to stress the advantages of neurodiverse conditions to line managers and other employees as well. Don't just look at the doom and gloom of the difficulties. There are great advantages as well.
I think another good point is this point that I came across in a case where there wasn't a proper handover between managers, and they issued quite a severe sickness absence warning on someone who had been in quite detailed discussions about their conditions with the prior manager, and there'd been no handover whatsoever, and that actually led to a tribunal claim, and a settlement was necessary in that case. So thank you, Alex and Jenna, for those tips, and they're really helpful, I think, for us all to bear in mind. We've covered a lot of challenging topics today, and it's really great that you've all attended. You'll be pleased to know that we have experience of training businesses on these issues, and we're offering interactive equality and diversity training exclusively for attendees and those who signed up to the webinar today, tailored to your business. And we'd like to offer you that at a discounted rate. So further details of this will be, and how to register your interest will be sent in a follow-up email you'll receive after this session. Excuse me. If you have any further questions about the subject matter of today's session or any other employment related inquiry, then please do feel free to get in contact with us. Our contact details of our learned presenters and myself today can be found on the invitation to the session and on our website, thomasmansfield.com. Our next webinar takes place on the 17th of November. And we'll be looking at practical tips for handling grievances and investigations at work. So please do go to our website to register. And we're putting together next year's webinar series, and would love to hear from you on topics you would like to see covered in the future. So by all means, do put them ideas in the chat box before you leave, and they'll be picked up afterwards. And that's all from us. Many thanks and goodbye.
Thanks, Meredith.